Hey everybody, welcome into the back room. I'm Andy Ostroy. We have a very interesting guest for you today. He is constitutional law scholar Eric Segall. We will talk with Eric in just a second, but first, thank you for tuning in today. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and/or post on our social media, and we'll read some feedback next time. And if you like the podcast, please rate and review and follow or subscribe, and you'll be notified every time we post a new episode. So, Eric Segall, he is a constitutional law scholar, professor, and author of the books Originalism as Faith and Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges. His articles on constitutional law have appeared in, among others, the Harvard Law Review Forum, the Stanford Law Review Online, the UCLA Law Review, the George Washington Law Review, the Washington University Law Review, the University of Pennsylvania Journal of Constitutional Law, the Northwestern University Law Review Colloquy, and Constitutional Commentary, among others. His op-eds and essays have appeared in the New York Times, the LA Times, the Atlantic, SLATE, Vox, Salon, and the Daily Beast, among others, and his television appearances include CNN, Fox News, MSNBC, and France 24. Eric, welcome into the back room.
Thanks for having me. Happy to be here.
I'm glad you're here. I'm sorry it's just such a boring, dull week. Nothing happening constitutionally. I mean, the courts are like they're all sitting around, the justices twiddling their thumbs, like binge-watching Netflix. There's nothing happening, right?
Yeah, it's been quite a week. Everything from homelessness to the future of the country is at stake this week.
Yes. All right. So I have so much I want to talk to you about, which includes the Supreme Court immunity hearing, the case in New York that Trump is on trial for, and a couple of other things. But I want to talk more in a macro sense about the Supreme Court itself. So let's start with, is the Supreme Court in serious trouble from a reputation and credibility standpoint, just judging from where it's been, what it's done, how it's acted, how it's ruled in the last several years?
That's a great question. I don't think that story is yet told, so I don't know we know the answer yet. And frankly, whenever a question is asked about the future of the court these days, or frankly, the future of Congress, or frankly, the future of the United States, the answer has to be, we won't know until this November, because if Donald Trump is reelected, I do think all bets are off in America. So, assuming Trump is not reelected, the Supreme Court will probably be fine, is my guess, much to my chagrin.
But just in a general sense, when you look at some of the rulings, when you look at a disregard for stare decisis and precedent, when you look at a disregard for protocol and ethics, the Clarence Thomas stuff, the inexplicable kicking down the road of the immunity case against a backdrop of ruling in 4 weeks on Colorado, okay, because I want to talk to you about all of that individually. But it just does seem like it's become highly politicized. And if it has become highly politicized, then there is a serious credibility and reputational consequence, isn't there?
Well, I apologize for this. I don't have a soundbite answer for that. I only have a long answer for that. So if you'll forgive me for that. So as a political progressive, but someone who thinks the Supreme Court has way too much power, and someone who is radically pro-choice and would vote for a constitutional amendment to enshrine the right to abortion in the Constitution, but someone who thinks Roe and Casey were also wrongly decided. I want to say this. I've been going around the country for the last 3 years giving the following talk. I understand if you're on the left, like me, you are angry at the court, you think it's terrible, everything is going south and all of that. But that's not what history tells us. So let me just give a quick few examples. Before the Supreme Court decided Marbury versus Madison, which is the first case to really articulate constitutional law principles, before that, Thomas Jefferson and the Congress canceled the court for a year. They were so mad at the Supreme Court in 1801 that they basically said, go home. Now, that's probably unconstitutional, but they did it anyway. So right at the beginning, the court's incredibly controversial, and the court said, and the Congress and the president said, go away. You can't even meet. We're turning the candles off. That's 1801. Dred Scott, the case where the court holds that Congress can't abolish slavery in the territories, is 1857, and that leads to unbelievable criticism of the court from all sides, not the South, of course, including the President of the United States, who effectively said, I'm going to do what I need to do to save the country. We get to 1900, and from 1900 to 1936, the court strikes down over 200 laws involving minimum wages, overtime rules, labor conditions, and worker safety. That's 35 years of terrible. During that time, Congress tries to end child labor, which was a huge problem in 1918. And the court says, no, you can't even end child labor. So all of that, we get to the Great Depression, and Roosevelt's reelected in 1936. And in 1937, excuse me, he goes on the biggest media of the day, and frankly, the only real media of the day. Now we have, 50 different kinds. Back then it was radio and radio only. And he said, we have to save the country from the court. Okay, that's 1937. And then he proposes his famous court planning, court packing plan. Bush versus Gore could have been a completely different episode. If Al Gore had not done the right thing and the classy thing, we could have been in constitutional crisis in 2000. So you take all of that. Is this that much different? No, I'm sorry, but it's not. This has been a broken institution from 1803 forward. And all we're seeing now is the results of Senator McConnell manipulating norms in the process to stack the court with ideological conservatives. And that's not a different problem than the Warren Court being stacked with liberals and changing America so dramatically, so quickly that it leads to Richard Nixon and a bunch of other terrible.
Mm-hmm. So I have to ask you why.
Sorry for that rant.
No. We've got nothing but time here. With regard to Roe and Casey, why were they wrongly decided?
As a matter, in my academic hat, as a law professor, my view of the role of the Supreme Court in constitutional cases is exactly the view of Alexander Hamilton. Not because I'm an originalist or I think history is that important, because he was the first really smart person to really think about what we should do with judges and overturning laws, because no country ever had that before ours. And when people against the Constitution said, this whole judge thing is terrible, it's not going to work out, they're going to have way too much power, Hamilton responded in the Federalist Papers, no, they won't, because they're going to be humble, they're going to be modest, and most importantly, they're the least dangerous branch because they can't enforce their own orders. They have no purse or sword, no money or army. But most importantly, he said, they would only strike down laws if there's an irreconcilable variance between a law and the Constitution. Clear error. And they all thought that back then. That was the overwhelming, it was the almost unanimous consensus in 1800. And if you think about it, that's correct, right? We don't want either Justice Sotomayor or Justice Roberts making major policy for our country. That's not what judges ought to do. So my view is, unless a law or a decision is totally at odds with the Constitution, judges should just let it go, and we'll vote. And our democracy is broken. We all know that. But there's still no better system. Would you rather have a broken democracy or a fight between Roberts and Sotomayor? And the fight between Roberts and Sotomayor is always going to be on the once removed grounds of legal doctrine, not really what's going on in the world. So I just think the court should do much less. Again, I want to be very clear about this. I would vote for a constitutional amendment enshrining the right to terminate a pregnancy up to the point of viability in the Constitution. I would vote for that. I would enforce that. But without that in the Constitution, it's not up to judges. It's up to people and voters. The same is true, by the way, for almost all major constitutional law issues. Not Brown. Brown was correctly decided. I give a lot of reasons for that. I think Obergefell, same-sex marriage cases, were correctly decided. The Pentagon Papers case, where they tried to have a prior restraint on political speech, that was correctly decided. And then other than that, the only other cases that I think the court got right when striking down laws are cases involving the 4th, 5th, 6th, and 8th Amendments. When we're talking about double jeopardy, self-incrimination, confessions, who should be in charge of that? Judges. Mm-hmm. Judges should be in charge of that. It's their courtrooms. They see it every day. They're the experts. You know what judges shouldn't be in charge of? Gun control, the balance between women's autonomy and the fetus, what everyone thinks about that. Gun safety versus gun rights. None of that should be up to the judges. It's just crazy. No other country does it that way.
Mm-hmm. But with regard to stare decisis and respect for precedent, which supposedly the court has built itself on, after having 50 years of settled law, was it a mistake for the court to overturn Roe?
That's a different question. But let me just address your first premise first, if that's okay.
Mm-hmm, sure.
The
Why
court
you're
has
here.
never, the court has never taken precedent seriously. It's a myth. It's really dumb. Not you. That idea is really dumb. Can I tell a quick short story about that?
Absolutely.
So it's 18. So the Constitution says Congress has the power to issue coin, gold and silver. It says nothing about paper money. Just doesn't. They didn't have paper money back in 1780, whatever. So Congress never prints paper money until the Civil War, when it needs to fight the war. So Congress, for the first time ever, makes this paper money legal tender, and there's hyperinflation, of course, because they just issued all these greenbacks. After the war, creditors wanted to get paid back in gold and silver. They did not want these newfangled greenbacks, these paper money that was going to hyperinflation. So eventually a debtor paid back with the dollars. The creditor sued, went all the way to the Supreme Court. Now this is 1870, and the issue in front of the Supreme Court in 1870 is, does Congress have the power to make paper money legal tender? It is the most important economic issue maybe the court has ever decided. Writing in 1937, 55 years later, a prominent law professor said that case, the 1870 case involving legal tender money, was the most discussed, watched, debated, argued case in American history from 1791 to 1937. More than Dred Scott, much more than. So the court rules that Congress does not have the power to make paper money legal tender. Now that's a ruling supported by the Democrats, who favored the creditor class, and opposed by the Republicans, who favored the debtor class, a complete reversal of today's politics. Grant gets I'm almost done with this story. Grant gets 2 picks on the day the case comes out. And everyone in the world knows he's only going to nominate people who reverse that legal tender case. He nominates 2 people. 1 year later, for no reason other than those 2 people were added to the court and 1 person left, the court reverses itself. The dissent in 1870 becomes the majority in 1871. The majority becomes the dissent. They're really upset. And you know what Democrat newspapers in New York say? They say, oh my God, President Grant packed the court with his own cronies to reach a specific result. And that's the most important case in American history from 1791 to 1937. In full view of everybody, he just packed the court to reach a result. That's the history of the Supreme Court of the United States. They only take precedent seriously when they agree with the underlying case anyway, or they're worried about their own reputation, which does happen. That last thing does happen. And by the way, Justice Thomas is in favor of everything I just said. Justice Thomas has been very honest. He doesn't even believe in precedent, effectively.
And so that's part 1. Part 2, was it wrong to overturn?
I was hoping you forgot you asked me.
No, I don't forget anything.
That seems clear. All right. So I know this is not fair in our world, but my answer is I'm not sure. I'm pretty, as you can tell already, as your audience can already sense, I'm a very opinionated guy. I don't know the answer to that question. And here's why I don't know. What I have been arguing for 40 years, literally 40 years, is that the right of women to terminate their pregnancy will never be stated until the people do it themselves. And during that 50-year span, our politics were warped by Roe in a way that favored the right and in a way that was just dysfunctional. Abortion is unbelievably important, and to me, I met my wife giving a talk to Planned Parenthood. When she was board chair of Planned Parenthood. So it's really special and important to me. But we shouldn't be fighting elections over it. We have wars and the economy and all kinds of other things. If the reversal of Roe and Dobbs continues to help the Democrats politically, and if 30 years from now, which I think might happen, the right to terminate a pregnancy is very stable in 47 states or 48 states, and if lower and if the poor can access abortions relatively easily, then yes, it was right to reverse it. If none of those things happen, then I'm not sure.
It's a really interesting subject. It's a very complicated, nuanced conversation. There's a part of me that really understands and gets what you're saying. In a perfect world, federalism, states' rights, people voting. That's how you should do all these things, is just vote, and then you get whatever you want or not. But life, as we know, doesn't work that way, right? So take 1935 Alabama, or wherever, like states down south thought it was okay to lynch black people. All right. So if we leave everything up to the states, including abortion, clearly some states, based on fanatical religious extremist ideology, might, as we see, right, Texas, other states, ban a woman's right to have autonomy over her body. Other states, liberal states, don't do that. So the question arises, where does the federal government where does the court system need to come in and say, no, this is crazy? We're seeing it with the ballot issue, right? The court has to decide so that we don't have 50 states running around doing crazy things. Why is it different here? Why isn't there a need for the Supreme Court to say, look, Texas, look, Georgia, look, New York, liberals, all of y'all can't just be out there doing whatever the hell you want if it abridges people's rights, it dehumanizes them, etc. Somebody has to step in and say, for the good of the quote-unquote United States, we are going to make that decision. Why is that not a compelling, legit argument?
So that's a really well put question, and it's the biggest question, and it's a hard question. I think we have to go back to first principles in a way that I think we can do successfully. Mm-hmm. I'm going to ask you a question first. I'll play law professor for 2 minutes, if you don't mind. What is your theory as to why unelected life tenure judges who we don't hire and can't fire, what is your theory of government as to why we should give them the authority to overturn the rules or decisions made by obviously more accountable political decision makers? Now, don't get me wrong, our Senate is, am I allowed to curse on the show? Is cursing okay?
Fuck yeah.
Okay. The Senate is fucked up beyond imagination. Mm-hmm. The Electoral College is pretty fucked up. Mm-hmm. So I'm not comparing this to a perfect Plato democracy type. I am comparing, so from 2006 to 2018, Justice Kennedy ran America. Where Justice Kennedy stood on every constitutional law issue, every one, with one exception, became the law of America. It was the law of abortion was Kennedy. Affirmative action was Kennedy. Free speech was Kennedy. Religion was Kennedy. One man, because they're 4-4 and he was deciding. Mm-hmm. What's your theory of government as to why we should give Justice Anthony Kennedy that much power? You didn't vote for him. You can't elect him. He's a lawyer. He's an elite lawyer. What are we doing?
All right, I'm going to play Eric Segall for a second. Yeah. I don't know.
Okay, let me tell you the original theory.
I don't know. I mean, that's a really good question, but when the system fails, when it's designed to succeed, it's like when you're a parent. You tell your kids, all right, I'm going to give you the responsibility. Here's some money. I expect you to spend it wisely. Don't do anything stupid. And then eventually they do it, and you got to step in and all right.
All right, that's a great example. Okay. Let's talk about that. That's a fantastic example. So I have 3 daughters. One's 32, and then I have 2 teenagers. One of these days, I'm going to write a book, Parenting Through the Generations, because I've raised kids before the internet and after the internet. Mm-hmm. Believe me, those aren't the same things. But anyway, so you say to the kid, let me give you a slightly different example to make it simpler. You're 16 years old, we're leaving you alone tonight, or you're 15 years old, we're leaving you alone. Go to bed at a reasonable hour. Go to bed at a reasonable hour. Mm-hmm. That's not that different than due process, equal protection, in terms of clarity. What's free exercise of religion, what's abridging freedom. Okay. So go to bed at a reasonable hour. In my head, what I'm thinking there is, all right, anything between, I don't care how early she goes to bed, obviously, that's her decision. 11 o'clock's fine, 11:30 is okay. If it's midnight, I'm starting to get a little not okay with it. 1 o'clock in the morning, all right, not reasonable, okay? What the court should do is look at laws and say, is this a law where reasonable people can disagree whether it violates the Constitution? Or is this a law where it just obviously violates the Constitution? Mm-hmm. So if I said to you, my 16-year-old went to bed at 3:30 in the morning, you're going to say, that's not reasonable. If you say to me, there's a constitutional provision that says no state shall deny any person the equal protection of the laws. And for 80 years, we put Black kids in schools that are less secure, less academic, gives them less opportunity to succeed, under state law, under actual state positive law. That is a absolute literal definition of a violation of the equal protection of the law. We know from history that the First Amendment was really only concerned with one thing back then: prior restraints, licensing schemes. You could get punished after the fact for speech. They just couldn't stop you from speaking before the fact. So if we do today a prior restraint on speech, meaning you can't even put this out there, we're censoring you. No, that's obviously a violation of the First Amendment. But everything else the court does, reasonable people can disagree about. So you were pointing out how important choice is to female equality in this country, and no one believes that more than I do. But where in the Constitution does it give judges the right to say to, I don't know, 100 million American people, you think abortion is murder, you're wrong. Because abortion's not murder, there's no other reason to deny women this right. Who are the judges to say that? If the Constitution says the president has to be 35, then the court can enforce that as a court. But when it says equal protection due process, the court has to give the political branches enough leeway to do their jobs. And that was the original idea. Judicial review, the act of striking down laws, was meant to be an emergency, last-ditch thing when all else fails and the elected branches go crazy, with the exception of issues involving juries, confessions, double jeopardy. That's what judges ought to do. And the best way of really making this point strongly is to imagine an Eastern European country or any country starting a new day. And they want a country like ours. They want a representative constitutional democracy. They'll change a couple of things, but they want to talk to us about how to do this. And they say, send us your experts on double jeopardy. Well, we're going to send lawyers, judges, police officers, maybe crime victims. I don't know, but that's who we're going to send. We want to know about self-incrimination. We're going to send judges and lawyers. We want to know the proper balance between gun safety and kind of limited gun rights. Or we want to know the proper balance between free speech and electoral reform to make sure money doesn't distort elections. Why are we calling lawyers? What do they know? I mean, if the Constitution said, judges, strike down all laws you think are wrong, would you be happy with that system?
No, but it's so complicated. You raised a good example, like when you say that, if a president has to be 35 a candidate has to be 35 to become president. That's black and white. And when it's black and white, it's great. But we know that it's the gray matter that gets us into trouble. For example, in the Constitution, it says nothing about me not being able to own an AR-15. It says nothing about presidential immunity, right? It says nothing about abortion. And so it's that lane that then becomes subject to discussion, interpretation. And I'm just saying, like, what I would prefer. And you're asking a good question, and I don't have the answer to that. And in theory, I agree with you. But what I'm saying is, I am hopeful, I remain hopeful that justices in that band of gray, rather than using politics and conservatism and this ridiculous notion of originalism and contextualism, which this country is not what it was.
Contextualism is important. Originalism is not. Sorry, go ahead.
Well, but times change, situations change. But
yes.
And I guess one man's contextualism is another man's drive a Mack truck through something.
Yes.
But to use the law as close as you can to interpret a case, to use common sense. So, for example, we're in court this week, and the insanity of this immunity hearing, where the justices were trying to get an answer to these hypotheticals that were bonkers. Like if a president sold nuclear secrets to an enemy, would that fall under immunity? And John Sauer's like, oh, well, it depends on the circumstances. Really? It really depends on the circumstances? Give me an example based on common sense where a United States president could be selling, keyword, selling nuclear secrets to an enemy. Yet this is where we are. Same with using SEAL Team 6 to assassinate opponents.
Let me tell you why we're here. I've spent my whole career trying to answer the question, why are we here? I can answer the question. I really can't. I can't fix it, but I can answer. I can tell you how we've arrived.
Well, that's half the problem. So let's go.
My wife teaches at Emory Business School, and she teaches problem solving and executive skills and that kind of thing. And she says, if you don't identify the problem, you have no chance.
Sure. How do you solve a problem if you don't know what the problem is?
So let me posit this to you. No country in world history, not a one, has ever done what we've done with our Supreme Court. And let me explain what we've done. We create life tenure, which back in 1791 meant you get appointed at 50 and died at 65 or whatever. They wanted judicial independence. We all agree judicial independence is incredibly important. Fixed terms get us judicial independence. So, but now, let's think about your job description in 2024. You have life tenure. The only way to reverse a constitutional decision is through a constitutional amendment, which you and I both know is not going to happen. So you have final say on all constitutional questions. You're interpreting an ancient document from a time when human beings were property and women were the property of their wives. Slavery, coverture, the whole shebang. The phrases and text these judges are asked to, quote, interpret, they're really creating, is incredibly imprecise. Due process, equal protection, cruel and unusual punishments, equal protection, whatever. Now you're a government official and you have unreviewable power for life as long as you get 4 of your committee members to agree with you. And you feel strong. You really believe abortion is necessary for women's equality, or you believe abortion is the cold-blooded killing of a human baby, or an unhuman baby. You feel really strongly that Americans need AR-15s for self-defense, or you feel really strongly that we have 420 million guns in America, which is absolutely insane. And if something doesn't happen soon, we're all going to die. You're going to do what you want to do. You're not going to be bound by pre-existing theoretical ideas like precedent, text, and history. And they're not. And I can give you, and I have written about endless examples. Let me give your audience just one obvious, clear-cut example. The 11th Amendment to the United States Constitution, I'm paraphrasing, says states can't be sued by citizens of another state. That's what it says. States can't be sued by citizens of another state. That's not ambiguous. That's not unclear. That's like President being 35. We know we're another state. The court has said, no, that applies to people of the same states suing that state. People in Georgia can't sue Georgia, just like people of South Carolina can't sue Georgia. Well, the word is another. We know what it means. So they just made up this entire other thing to avoid the direct consequence of reading the word another. Here are some things that are not in the Constitution the court has found to be constitutionally protected. And on abortion, this becomes very ironic. The right of an adult to refuse medical treatment. A competent adult has a constitutional right to refuse medical treatment, not in the Constitution. You have the right to raise your kid as you see fit, not in the Constitution. Congress cannot tell state legislatures to help it implement federal law, not in the Constitution. Sovereign immunity for the United States government, not in the Constitution. Privilege for the president, not in the Constitution. This is why Lawrence Tribe writes a book called The Invisible Constitution. This is why Akhil Lamar of Yale Law School, who's probably one of the most famous law professors in the country, writes a book, The Unwritten Constitution. Our Constitution has nothing to do with the piece of paper in Washington, D.C. that's under a thing. Our Constitution, and I wrote this for the Harvard Law Review, is what the Supreme Court says it is. Our Constitution is what the Supreme Court says it is. That was not how this country was supposed to be governed. It's supposed to be a conversation between the president, the Congress, the court, and the states. And in that dialogue, we get to good answers unless the constitutional error is completely clear. If it's completely clear, as it was in Brown, then the court should strike down the law. If it's not completely clear, then I still haven't heard from you a theory of government that suggests Justice Roberts or Justice Kagan, whichever one has the 5 votes, is a better decision maker for issues of gun policy, election policy, and so on, than the people of the United States acting through their representatives, which again is broken, but not as broken as Roberts and Kagan.
So, okay, that's all very interesting, and much of it I agree with. So let's take the Second Amendment just for example. Okay, the Second Amendment is very clear. It says citizens have the right to bear arms, and the second part...
Hold on. Well, no, but a well-regulated militia...
I was getting to that.
Okay.
Because that's the crux of my point. A well-regulated militia. So when you think about it in terms of a country that was just born, right, was founded on the desire not to be run and governed by a monarch, okay? So
ironic, in terms of this week's events, that's an ironic statement, but you're right.
Incredibly ironic. Yeah. And so the political times were obviously extremely different. And it was also during a period where we were talking about muskets, right? So now you go to 2024, I can't fathom how a Supreme Court justice, whether it's an Alito, who's brilliant, or a Kagan.
No, he's not. He's not. He's clever. He's clever.
They're smart enough, put it that way. I'll give them their props. They're smart people. How do they not know, if they just strip aside their own politics, strip aside their own extremist views, and just look at the verbiage? I think a high school kid can go, no, they weren't referring to AK-47s, right? And they weren't talking about every schmuck on the street. They were talking about a well-regulated militia. It's clear.
You don't have to do a high school student. The most famous historians and constitutional, not law professors, I'm not talking law professors, historians, all agree that Heller, that's the case where the court first held in 2008, that you have a right to own a gun, separate from the militia. They all agree it was terrible history. It's just wrong. It's wrong. It's just wrong. But listen to me. You're not looking at this. I apologize for the statement, but you're not looking at this correctly. Ask me how many hunting trips Justice Scalia took in his life that were totally funded and paid for at very, very, very special, nice places. The answer is 3,800. And in fact, he died on one of those expensive hunting trips. Scalia was obsessed. I'm going to tell you why Heller was decided the way it was, which is the cause of all of this about the Second Amendment. And it's not what you think. It's not what people think. And this is going to sound to people very extreme. I've documented this. I mean, it's just what it is. Chief Justice Warren Burger, a gun-toting Republican from the Midwest who loved his guns, said in the 1970s, he saw the NRA shift. He saw the NRA shift from a gun safety organization to a gun profits organization. Now, Justice Burger, if you asked 1,000 law professors, they might say he was the least smart justice of the last 50 years. And his character left something to be desired. But again, he was a gun-toting Republican from Minnesota. And he said this crazy idea that the Second Amendment has anything to do with the personal right to own a gun separate from militia. He didn't say it was wrong. He didn't say it was he said it was a fraud. He picked that word for a reason, because this was not an organic thing that happened. This was the NRA paying people to go out and make these bizarre arguments that no one had ever made before. You take that part of the NRA shift, and then you go, and this, I'm just saying, I know this is going to sound crazy. Don't cancel me for this. They wanted to own the libs because of Roe. If there's no Roe, there's no Heller. If Roe is never decided, there is no Heller. I am so sure about that, which is why a Republican judge in 2008, a Republican judge in, the Carolinas, place with a lot of guns. When Heller came out, he wrote this very famous law review article. And by the way, very few judges can do that. He criticized the court as a sitting federal judge. There are only about 5 judges in the country who have the reputation to do that. But this guy did, Judge Wilkinson. And what he said was Roe and Heller are exactly the same. The Constitution doesn't tell us whether women have the right to terminate their pregnancies. The Constitution doesn't say anything about the private right to own guns, only talks about the militia. And the court erred terribly in both of those, and for the same reasons, and it's going to have the same effects, which is to distort American politics. Now, in the case of, and in the case of both, depending on one's perspective, we're talking life and death. So you're looking at this from the lens of the court being a court and they're doing law. The court is not a court, and they don't do law, and they never have. Because the description I gave earlier, you have life tenure, unreviewable power, interpreting imprecise phrases, and you can't be reversed. That temptation is just too much.
I totally agree with you. And I think it's amplified more today than ever before. And
I'll tell you, FDR would not have agreed with that. FDR would have said, by getting in the way of the New Deal, he did say that. We have a crisis. We have a catastrophe. We're in a Great Depression. and the court is stopping us from getting out of it. What's more important than that? I mean, people were jumping out of windows. I mean, the Congress and the president are working together to try to fix this. And these men from 1880, who grew up in 1880, 50 years earlier, are using their 1880 values to a 1935 world. And FDR, I mean, we have to save the country from the court. I mean, even Obama didn't say that with citizens, right? I mean, it's not. So I don't want to be a prisoner of the moment. And my wife teaches me about recency bias all the time. I think the left is going through recency bias.
No, that's a fair point. It's a fair point. And in history and context is certainly important. So last question on immunity. As a constitutional law scholar, when you were listening to what happened yesterday, what is your biggest takeaways?
Nausea. I thought, as did almost all law professors on both sides, all sides, that the court was going to be extremely skeptical of immunity, was going to come down hard on Trump's lawyer, and come up with some rule that, of course, President Trump is not immune here. Now, they were going to do all of that in a way that would delay the trial past the election, because above all else, this Supreme Court, this isn't true for all Supreme Courts. Justice Kennedy, the most powerful judge in the history of the world for 18 years, was a Republican, and didn't vote Republican. He was pro-choice, pro-gay rights, et cetera. This Supreme Court, above all else, is a Republican organization. 3 of the 6 justices worked on Bush versus Gore for George Bush. 3 of the 6. Justice Roberts has been a life, so they're going to do what is best for the Republican Party. In Bush versus Gore, that was easy to see. We want Bush, not Gore. That was easy. We thought the Trump thing is different, right? It's not clear what's in the best interest of the Republican Party. Maybe what's her name, Nikki Haley's in the best interest of the Republican Party. Who knows, right? So we thought that they might take this immunity issue and just say, you know what? We can't have presidents doing these kinds of things, but there were some factual issues. We remand it. It's going to take some time. It's not what happened. That's not what happened. They spent a lot of the argument figuring out a way to give him immunity in this case. And really, as cynical, or I would say realistic, as we all are about this Republican committee of people that are making these decisions, no one saw that coming. And so we're all of us, now there were some law professors out there who have a very different take. Other law professors, a minority, are saying, they're just asking questions, that's what they do, and they wanted to show off, but they're going to do this in a way that is consistent with the idea that, of course, Trump doesn't have immunity. I don't think so. I don't think it's going to happen at all. I think they're not going to say he has immunity, but they're going to make it very hard for the lower court to say he has immunity. And that's all they need to get past the election. So I want people to understand that Justice Kavanaugh reflects what is true about all of them. Barrett also. These are all people whose entire sensibility in their formative years, and these are people like us. They go to the bathroom, they have dinner, they go on vacations, a lot of vacations, more vacations than we do. They're just like us. And so their formative years were all spent in Republican Party politics and in furthering the interests of the Republican Party. Thurgood Marshall voted liberal 99% of the time. And that just tells you what that job does to people, because I agree with Thurgood Marshall 99% of the time, but the Constitution can't mean what Thurgood Marshall and I think it means 99% of the time. You can't give a government official unreviewable power for life. You just can't do that. They will do exactly what the court has done for 150, 200 years.
So another justice who likes to take expensive vacations that in fact are paid for, to use your example, and whose wife is, by all indication, very involved in what took place on January 6th. Should he be recusing himself from this decision?
Well, 100%, but that's assuming he's a judge. Your question assumes we're talking about a judge. And I'm sorry, I know this is going to throw your audience off, but I'm the guy who wrote the book that says they're not judges and it's not a court. So if you look at it as him not being a judge, then, well, I don't know if he has to recuse himself or not. As a judge, he clearly has to recuse himself. It's not close, but they don't. Can I tell Justice Kagan's story about this?
Sure.
Because I think everything we've talked about in the last 35 minutes is reflected in this story. And it's a little personal, and it's a little look at me, Louis. So I apologize for the look at me, Louis part of this. This will give your audience, I think, the best flavor. Elena Kagan was a Solicitor General of the United States, working directly for President Obama and taking his orders when the Affordable Care Act lawsuits were filed in the lower courts in 2010. She was his Solicitor General. And the day the law was passed, she wrote to Lawrence Tribe, Larry, professor of Harvard Law School, Larry, we have the votes. Yay. Okay. Neil Katyal, her deputy, emails her very shortly after that and says there's going to be a lawsuit filed in Florida tomorrow. We all knew Randy Barnett was already working on that. There's going to be a lawsuit filed in Florida tomorrow. Do you want the Solicitor General's office working on this lawsuit in the lower courts? Let me explain that real quick. The Solicitor General's office is the part of the Department of Justice that represents the Supreme Court, represents the government in the Supreme Court. Mm-hmm. It almost never goes to lower courts. But on world famous big cases that are ultimately getting to the Supreme Court, sometimes they do. So that's a fair question for Neil to ask. Do you want us handling this case below? Answer, yes. There's a meeting at some time, but don't say anything more about it. And then she testified under oath that from that moment forward, she said, I don't want to hear about this case. I'm not involved in this case. You have the final authority to make all decisions, to her deputy, Neil Katyal, who then went to argue the actual case in the 11th Circuit Court of Appeals, where I live. She has to recuse. She just does. There's a rule that says you can't be a judge in a case, but you are a lawyer below. Her office was the lawyer below. Now, that thing that she created, why did she do that? Because she ended up recusing in over 300 cases. She ended up recusing in a big affirmative action case. She ended up recusing in a big immigration case. But this one was the only one. She said, don't tell me about it. I want it. A year later, she gets put on court, and then Obamacare case comes. Mm-hmm. And there is no question she has to recuse. So I write that for Slate, and my career changes. It goes viral by law professor standards. A liberal's lament why Elena Kagan has to recuse in the Affordable Care Act case. That eventually I write it for a bunch of newspapers, including the LA Times. And this is the part of the story that gets important. A liberal's lament why Justice Kagan has to recuse. Because I love Obamacare. I think it was the right, I don't love it, but it was the right thing. It should have passed. It'll save lives. And I said all of that. I get a handwritten letter, handwritten. I was kind of impressed by that, from a doctor in Los Angeles who says, Dear Professor Segall, I'm not a lawyer. I read your op-ed here and elsewhere about Elena Kagan recusing. I have one question. You seem to think it's more important for Elena Kagan to obey the technical rules of recusal than 35,000 Americans to get health insurance next year. And you think it's more important for Elena Kagan to abide by this part of the law than for American lives to be saved, because you yourself have said you're very strongly in favor of Obamacare. Why in the world would you make that decision? And that letter threw me for a real existential crisis, because on the one hand, the law was clear. On the other hand, if she does it, disaster. Mm-hmm. Is the case. If she does not vote in the case, Obamacare struck down. What happens? That's how they feel every day. Like that, right? I mean, so do you have an answer to the question whether she should have? Trust my instincts. I mean, on the law, I am correct.
Well, I would say, and this is probably not a satisfactory answer to you as a constitutional law scholar, but the expression desperate measures for desperate times, what we are dealing with in this country today is unprecedented. It's just absolutely unprecedented. Nixon was like jaywalking compared to what we are experiencing. And Kagan's actions, or lack thereof, with regard to recusal, were to serve the nation, not herself. She didn't
That's fair.
Enrich herself. And it was for a really, really, really good reason. Clarence Thomas seems to be all about enrichment, and his wife is involved. She's all about the enrichment. And this particular case, I mean, I don't want to be a Chicken Little, sky is falling kind of guy, but literally, I think American democracy is teetering on the precipice of ruination. And so I understand purely if you just put blinders on and say Constitution, law, I agree with you 100%. The argument is a fair one. But when you actually look at the two sets of circumstances and the context and the consequences, not to the judges, but to the country, to American citizens, I get it. But then I understand the argument of like, I had to rob the store because my kids were starving. Well, if we all got to do that, then there's no laws, right? You have anarchy. So I get it that either we obey laws or we don't.
I'm not saying that. No, I'm not saying that.
I'm saying that.
Okay. I agree with almost everything you just said, and I am not comparing Justice Kagan and Justice Thomas. One is a outstanding person with impeccable character, and one is a corrupt. Mm-hmm. No one has written more critically of Clarence Thomas than I have. So no, really. So I'm with you there. Here's the thing. This is what I took away from that letter that sent me spiraling for about a month. Mm-hmm. What I eventually wrote back to him, by the way, was I'm not a health law expert. I'm a lawyer. So when I say I love Obamacare, that's not an expert opinion. That's just kind of a personal, that's a terrible answer, but that was the only one. When I thought about it more, that's precisely the problem I've been writing about for 40 years. It's too much temptation. Mm-hmm. It's too much temptation there've only been Justice Souter was a man of incredible humility and incredible modesty. And you know what that led him to do? Quit. Mm-hmm. He quit his health was fine. All of that was fine. It takes enormous character to have this job and exercise it with humility. And that would be true for you and me. Mm-hmm. So, I've told you now 3 times, I think, during this conversation, I thought Roe and Casey were wrongly decided. You put me on the Supreme Court, I have life tenure, unreviewable power. I don't know what I'm doing. Mm-hmm. And that's why the court's broken. And that's why it's been broken forever. And that's why no country in the history of the world have given judges this much power. Mm-hmm. It doesn't make any sense. It's not what we want lawyers to do. I don't want lawyers deciding gun policy. I don't want lawyers deciding health policy. I do want lawyers and judges deciding double jeopardy, self-incrimination, and I want them to implement the Constitution where it is clear.
Is it a fair argument on the left when they call out for stacking the court, expand the court?
Well, so in 2016, when Scalia died, I had just finished the most important legal conference of my life that I had organized. And I promised my family, we're going away on vacation, and I'm not opening my phone. We go up to the mountains in North Carolina, we're playing Scrabble. Someone texts my wife and says, what does Eric think about Scalia? And I'm like, I don't want to know. Scalia's dead. Salon is calling. Daily Beast is calling. They got to write all this stuff. And then I started thinking about what we need is a Supreme Court that is evenly divided between 4 conservatives and 4 liberals. I wrote that in the New York Times. I wrote that in law reviews. I wrote that every year. I was right about that. There's a lot of stuff on this conversation we've had where I would say, I don't know, I'm guessing, I'm doing the best I can. It's not on this. On this, I'm right. If we're going to give judges this much power, then the only way they should exercise it is if one of the Republicans agree with the Democrats or one of the Democrats agree with the Republicans. Because then at least we have a minimum amount of bipartisanship. And when the court is divided 4-4 among liberals and conservatives, that suggests to me the court should not act because there isn't enough certainty for the court to act. Because although I'll agree with the liberals almost all the time on policy grounds, I have to be modest and recognize that half the country will disagree with me on those questions. So it's not a question of adding to the court. It's not a question of packing the court. It is a question of balancing. So I am in favor of adding 3 seats, getting to 12, making it 6-6. And by the way, the original number of justices, if you want to talk about originalism, 6.
Right. Even the court's been expanded before, clearly.
Yeah, but I don't like the word expansion. I'm talking about balancing. For me, and by the way, you're talking to this is going to sound really grandiose. I apologize in advance for how grandiose this is going to sound. I am the only liberal in the country who took that position. I'm a board member of the American Constitutional Society, the liberal alternative to the Federalist Society. Their slogan was, "We need none." That was their slogan in 2016. We need none. My slogan was 8 is great. We have to figure out a way to limit the court's power going forward in a nonpartisan way. If you have a better idea of how to do that than balancing the court, I'd love to hear it, but I can't think.
I love it. I haven't heard that before in terms of like a mandated bipartisan count. And I think I mean, it's radical, it's different, but I think that's the answer. That's
I drafted the whole
it's,
statute.
It's an answer. It's an answer that makes sense because this shit needs to stop being decided based on one or two or however number of people's own personal religious extremist views are. I mean, it's insanity. You know.
Okay, now you say now. Listen, hold on, stop. I got to interrupt you. You say religious extremist views. Now, I am not a person of faith, and I think religion is killing this country. But having said that, this goes both ways. This is not Justice Marshall is the most important civil rights litigator in the history of America. He litigated Brown versus Board. His record at the Supreme Court as an oral advocate, this is unbelievable, was, I think, 21-3. 21-3. And they were mostly civil rights cases to a racist court and a black man standing there in 1930s and 40s. An American hero by any definition. Same thing with Justice Ginsburg, the most important gender rights litigator in American history, and it's not close. It's not even close. She also had a crucial role in the gay rights cases, a behind-the-scenes role in the gay rights case. So those two people are American heroes to me. They are absolute heroes. They get to the Supreme Court and they vote liberal 99% of the time. How can that be?
No, I agree with you. And I should have said religious extremism and political ideology on both sides because I understand that point. I totally agree. And I think forcing people to look beyond their own politics and their own religious beliefs and ideology in whatever shape or form it takes is for the better of the country because then we're looking at law, we're looking at common sense, we're looking at things that affect, on the one hand, I say, okay, if 2/3 of the country believes in something, why is the court going against that? But I also think like, okay, if 2/3 of the country thinks it's okay to, put babies in cages, that doesn't mean we should say that's okay.
But that's not, but the better question is if 2/3 of the country wants reasonable gun control and the radicals on the court don't, that's the better question. And that's what's happening today.
But that's really where I was going to. It's that, yes, Democrats, progressives do this stuff, but, look at the 14th Amendment issue. Show me an issue of great significance to the left. Show me an issue that most of the country, most of the left wants, where a Republican, where a conservative Supreme Court justice either really asks sincere questions that goes against their side or actually votes the way liberal justices have. I do think there is both sidesism on some level, but there's no comparison. We are our court system today. We are not in this shitstorm everywhere in this country because of progressives. We're there because the right-wing extremists, both politically ideological and religious, are injecting their own personal beliefs into the nation's governing and the legal system. And yes, it exists on some level on the left, but it's why I always get upset when you hear like, oh, be careful the president. A Democrat can come in and do the same thing. Well, Democrats won't do that. A Democrat's not.
That's a different conversation.
Yeah, but it is a whole different conversation. And that's where Republicans win because they get to do the shitty stuff. And then they know that the Democrats won't do the same shitty stuff. And so it's insanity, but it's largely coming from the right. And so,
well, you say that, and I am a progressive, and I've never voted for a Republican nominee for president, and I'm sure I never will. Well, I'm pretty sure I never will. But listen, hold on a second. There are really good faith beliefs that what the Warren Court did across the spectrum of constitutional issues was bad for the country, bad for the people, and absolutely outrageous for judges to impose this on the American people. It's very interesting. One person, one vote, a concept we can all get around, right?
Mm-hmm.
One person, one vote.
Sure.
Well, it turns out it's not in the Constitution. And there are other ways to do this. Now, that's one where most of us agree that's the right answer. But you know what? Giving the judges the authority to make that the answer when states don't want that to be the answer directly led to Shelby County, directly led to the court striking down on the most frivolous of grounds, the most important voting rights, maybe the most important law this country's ever passed, short of maybe Social Security and Obamacare. So, when you say it, I think what you're feeling here is not that the Republicans do it more, it's that they have the opportunity to do it more. Because throughout American history, the court has been a conservative, anti-progressive institution because the court is made up of elite lawyers. And generally speaking, elite lawyers are very not progressive. That's just how it works. But every time Democrats have had the opportunity to do these kind of things, they've done it. And the reason for that is simple. Our Supreme Court violates a golden rule of governance. Never give a government official unreviewable power.
Yeah. I mean, I guess the point I'm making connects back to the conversation we had about Kagan and Thomas. I'm not saying Democrats are without fault, but I will say, for the most part, when Democrats do something, I do believe that they are genuinely caring about the people. They may fuck up, they may make mistakes, it may end up being the wrong decision, but their motivation is not self-serving, it is not nefarious, but that's what motivates the right. Whatever's happening with Trump, whatever's happening with abortion, this is not for the good of the people. This is self-serving. And that's where it gets really dicey. Because yes, we could spend hours giving examples on both sides. But the left, I do believe, throughout modern history at least, has a genuine concern for doing things that help those that need that help. And what we have seen out of the right over the last 20, 30, 40 years perhaps is not that.
So Jeffrey Toobin, famous Jeffrey Toobin, who I saw back with us a few weeks ago.
It is deliciously rich to watch Jeffrey Toobin talking on TV about Pecker.
That's really good. I like that. Jeffrey Toobin ended the book, The Nine, or began it. I forget if it's the first sentence or the last sentence. It's a terrible book. But he does end it by saying, we get the court we deserve. What you just said is why I'm a Democrat. Everything you just said is why I'm a Democrat. And I, of course, politically, I agree with you because I am a Democrat. So but I don't think it's fair. I don't think what you said was fair at all. So for example, if one really believes abortion is murder, and the movement doesn't believe that. The movement is about keeping women barefoot and pregnant. But there are individual Americans, millions of them, who honestly believe it's murder. I've talked to these people. I know. I mean, they honestly believe that. If you believe that, then you think Roe and Casey were the equivalent of the Holocaust. We're killing babies, millions of babies every, you and I can't say they're wrong. We can just say we disagree. And that's the last thing I want to say in this podcast, if you don't mind. Judge Richard Posner, Dick Posner, who, if your audience doesn't know, was the most famous judge not to be in the Supreme Court, maybe in American history. And he was named America's leading public intellectual of the 20th century, not legal intellectual, public intellectual. We are very good friends. He has Alzheimer's. It's very sad, but we were very close friends when he was not sick. And I'll never get past his description of constitutional law as being accurate in almost everything anybody needs to know. If you and I started a debate, I say Godfather 1 is better than Godfather 2.
You'd be wrong.
You say Godfather 2. Let's talk about it for 2 minutes. So I say, well, Godfather 1 has Marlon Brando and Godfather 2 doesn't. To which you say Godfather 2 has Robert De Niro and Godfather 1 doesn't. And then we go on and on and on with the arguments. At the end of the day, I say, I think it's better. And you say, no, 2 is better. That's not what we mean. Mr. Posner said. What we mean is we prefer Godfather 1 to Godfather 2 because there is no objective metric to resolve that debate. Now, we can debate whether Michael Jordan is better than the 6th best player on the Atlanta Hawks. That's a stupid debate because we know there's only one side of that debate. But one-sided debates don't go to the Supreme Court. Mm-hmm. Only two-sided debates go to the Supreme Court. And when that happens, it is values, taste, ideology, not law and logic. So when you're measuring what the Supreme Court does, you have to always remember it's not about law and logic. It's about taste and value. That's too much power.
Mm-hmm. Well,
it's too much power for Thurgood Marshall. It's too much power for John Roberts, and it's too much power for David Souter, who, as far as I know, is the only modern day justice who recognizes that it's too much.
No, I agree with you. But just imagine now I sat here and I said, I think Godfather 3 is the best because it had Andy Garcia. Think about that conversation we'd have. But we're going to end on that note. I literally could sit here for hours talking to you. This has been a fascinating conversation. You're a truly smart guy when it comes to this stuff, and I appreciate your insights, and I hope you do come back and talk to us again and continue the conversation.
Thank you so much. Your questions were awesome, and I really enjoyed it.
All righty. Take care. This episode of The Back Room was edited and produced by me, Andy Ostroy. It was co-edited and co-produced by Maddie Rosenberg and co-produced by Jen Hammoud. Our theme song was composed by Andrew Hollander, and our logo was designed by Cricket Langell. And special thanks to Patricia Wind. Please take a moment to rate and review the podcast, and also follow or subscribe. Until next time, keep your eyes on Washington, Hollywood, and your own backyards, and have a great week.